Welcome to Caracomp Insider, where high-tech facial recognition meets real-world intelligence. Imagine a defense attorney turns to you in court and says, "Walk me through exactly how you compared those two faces. Step by step. With documentation." Would you feel confident, or would there be gaps you'd rather not explain? Here's why that question matters right now. If you're an investigator, a PI, or anyone working insurance fraud cases, the rules around facial comparison tech are changing fast. Not disappearing, changing. And the driving question isn't whether you can use this technology anymore. It's whether you can prove how you used it. Let me unpack what's actually happening in 3 parts. First, some agencies are finding workarounds, and it's backfiring. In places that have banned facial recognition, some law enforcement shops are routing requests through out-of-state agencies or third-party contractors. Think of it like asking your neighbor to buy something you're not allowed to buy yourself. Technically, your hands are clean. But legally, every handoff in that chain creates a point where evidence can get challenged or thrown out. For investigators, that means a case you spent months building could collapse because of how you got the ID, not whether the ID was right. So what's the alternative? That's the second point. States like Virginia aren't banning the tech, they're building guardrails around it. Virginia just rolled out a statewide facial recognition program with audit trails, supervisor sign-off, and strict rules on when it can be used. Think of it like the difference between a highway with no speed limit and one with clearly posted signs. The road's still open, you just have to follow the rules. The policy conversation has shifted from, "Should this exist?" to, "Can you show your work?" Now, here's where it gets interesting. The third piece is about documentation itself. Courts and defense teams aren't attacking the tools anymore. They're attacking the methodology gaps. The legal risk isn't in using facial comparison. It's in being unable to reconstruct your process after the fact. The math behind enterprise facial comparison, called Euclidean distance analysis, produces a measurable similarity score. Think of it like a ruler for faces. It gives you a number, not a gut feeling. That's defensible in court. "I looked at it and it seemed right" is not. And this doesn't just apply to cops. PIs face the same evidentiary standards in civil court and insurance litigation. But here's what most people miss. The investigators most at risk right now aren't the ones using facial comparison technology. They're the ones using it without a reproducible, documented process. Methodology itself has become evidence. So here's the bottom line. Facial comparison tech isn't going away. It's getting regulated. The new standard isn't whether you used it. It's whether you can walk a judge through exactly how you used it. Investigators who document their process will thrive. Those who can't will get picked apart on the stand. Something worth keeping an eye on. The push right now is for simpler documentation tools that fit a solo workflow. Because the answer to over-regulation isn't less documentation. It's making good documentation easier to do. Now you know something most people in this industry don't. Use it. And when you're ready to put it to work, caracomp.com. We'll see you tomorrow.